Oh, the judge is giving them the business. Let's see.
Proceedings, you would of course be subject to
it's the subject
removal
for us.
and forfeiting your right to be present in this courtroom.
Kumbaya, my
All
Lord.
right, is there
Kumbaya.
the jury out, Mr. Brooks? I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do
long
that.
blinking for.
I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about
that's pretty good.
Objections to strictly jury instructions, or the...
I'm not addressing those at this point, sir.
Asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right, I'm not addressing any of those filings. I've previously addressed those. It may not be to your satisfaction, but...
Remember what you said, to be honest about those.
And I'm not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record. And they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings. So
I like that. That's funny. This is something that Darrell complains about later. He's like, you told me that it wasn't time to put no evidence in. And then you never told me when it was time, and then I never put evidence in. This is prejudice. Yeah. It is, Darrell. This is so prejudiced. This is the most prejudice of all the prejudice. Okay? It's the prejudice for me. Oh. Darrell and his evidence. It must be up his sleeve. He got a lot of space up his sleeve. I'm thinking it's up his sleeve. Who else has come in while I've been running my mouth? Hey, Michaela. Hey, Pumpkin.
You will have an opportunity after the state presents their case in chief and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law.
Oh, he appealing this?
But I expect you to not bring that up at this point in time.
Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions.
Miss Vivi, hey boo.
I am, just for reference for everyone, I've read through 44 pages of 69.
Yeah.
And so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. and then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
Yeah.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not.
I was like, y'all really trying to make me have to do this trial? He was like, I can't believe y'all ain't gonna let me use any of the tactics that I've read about, you know, the sovereign stuff. It seemed to work in petty court. It seemed to work in the regular stuff, like getting out of tickets. Why can't it help me, you know, to get out of this, you know, extreme murder case? Why can't it get me out of this too? You won't even let me say the things that I'm trying to say. Oh, my conduct didn't demand anything.
making a judicial determination that I cannot.
Jody.
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the...
My birthday isn't today. It's one of my babies in the chat. That's one of my chat babies, my honey pots. Okay. It's not my birthday. My birthday gone. My birthday was 2 days ago. Oh, but thank you, Colonel. Thank you.
Capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
No,
Objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Because I said so.
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which
definitely
this court
Your Honor.
honored and granted.
That is inaccurate
And
because
you, Mr. Brooks, don't interrupt me. Okay, now we're that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not
please,
my intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you...
I love that. I'm seeking to merely understand. It's all I'm merely seeking to merely do. Merely.
you the understanding that you want.
I'm not
all right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand
This
the
is
nature
merely
and cause
for me.
of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt.
You sound like
it's
Darrell
been a
now.
couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not.
This poor judge trying to explain shit to a Darrell. That's a terrible job. Oh, how can you do anything yet, fool? The trial hasn't started. You should have kept your free lawyer. I know that's right. He knew he was going to jail. At least he could do was entertain himself and others, apparently, was the plan. He definitely pulled that shit off.
It's just a tactic by you. The fact that
that is his name, Edward, isn't it? Oh shit.
Doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
Yeah.
I hate when he like he'll say something to her, and then he'll like while she's responding to what he said, the way that he stares at her, it's like the whole reason he said anything to her was so that he could then watch her respond, right? Like he just does this thing like, I mean, it just seems like it's just not fair. Yeah, I figured that out, D. Barbie, after it took me a while. I'm gonna be slow. I forgot his middle name was Edward. Eddie. Hey, Eddie. Shut the hell up, Eddie.
So at this point, Mr. Brooks,
I respectfully
stop interrupting me, please.
It's a respect for me.
Stop interrupting me.
My hand's gone, y'all.
If you have an objection, write it down.
I thought that applied to me being.
It's applying right now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand?
Mr. Brooks, I've been more than patient with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there a reason why?
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir.
I ain't got to do none of that.
You filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction, but I have addressed them.
That's inaccurate,
all right?
Your Honor.
Some of your filings, sir, you're interrupting me yet again because you're not letting me finish with my...
You said that and it goes, with all due respect. You'll be like, fuck you, Your Honor, with all due respect. Look, and then he does this stare.
Explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires.
This judge got a nice head of hair, does she not?
Me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in. It will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case. Madam Clerk,
strong like bulls.
Judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up
it's just
subject matter jurisdiction.
All I did was mirror, Judge. I don't understand the problem.
Try to seek to understand.
I was just meeking
and
merely.
I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all.
I should be present. It's not fair that you keep putting me out into that place. You know what I'm saying? Can I go into that place? Darrell, you just actually asked to go in there like 120 seconds ago. Like, you just got finished asking her if you could go back in there. And now you're like, I should be in here for everything. I should not be in that other room. None of this stuff should be happening. And by the way, can I go over there in that other room, please? Thank you. Oh my God, Darrell. You deserve to be right where you
I
at.
should be able to understand, which I do not. Once again, I do not understand
like
the
a you
charges,
problem,
the
Darrell.
nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be.
Yeah, Deborah. Yeah, Judge Darrell is definitely a. Yeah, she waifu. Judge Darrell is waifu. Okay, she's waifu. She waifu. She waifu.
Disruptive, disrespectful in any
Thank you, Deborah. Mama love you. Yes, she do. Woohoo.
manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the
you're just gonna end up with more time if you start axing things. You can't just be walking around axing stuff. It's dangerous. That thing is very sharp. You know what I'm saying? I can't believe you're even saying this to a judge. You're like confessing to a crime here, talking about axing people. You know what I'm saying?
attorney gave the right the waiver back in the way that I felt that it should be altered.
Oh my God.
And you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you.
Yeah, because you did take it off.
That should have let you know right there further that I did not understand the.
That's funny. That right there should have let you know that I wasn't shit. That right there should have told you, Your Honor, that this right here was going to be the hardest thing you ever had to fucking do. That you was about to have to be in for. You was about to be in for it. You should have known that from that thing I did to that paper. I mean, literally, honestly, think about it like this. Darrell, you could have crossed out something and replaced it with, y'all need to let me go. And then handed that back to the judge. Do you think that means they're going to let you go? Because my point is you altering the paper don't mean shit. That's what I'm getting at. Okay? Get it? Got it.
Proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification.
It's just a meerkat, Your Honor. Don't be scared. It's a meerkat. That's all.
What is going on?
It's just
it's not to be disrespectful.
All I'm trying to do is merely.